I would like to present Nokukhanya, who is a specialist in dispute resolution at the Compliance Advisor Ombudsman. It's part of the World Bank group, and she's also from South Africa. So welcome.
Thank you.
And she's going to talk about the African way of doing justice.
Okay, thank you. Like I said, I've already presented in the other room, so I just want to double check that everybody's okay with me presenting here. This was my slot. I was supposed to be here, but they bumped me up because the other speakers were not there in that other room. Yeah, they did. There were two panels back to back, and there was one speaker for both panels. And so I was moderating, and they said, well, you might as well just talk. So I did. So that was just the disclaimer. Yeah. So I am a lawyer, and I had been practicing law for about 5 years. And one of the clients that I was working with then invited me to come and help them with the mediation process. It was an employee situation, employer-employee situation, and as I was mediating this process, I actually realized that the parties that were in dispute, although they were relying on the law to try and say who's right, who's wrong, there was actually a lot of stuff that was going on that was not being articulated. In any case, we were able to resolve the dispute, and I took a really keen interest in mediation because I thought it provides an avenue for people to explore the root of the problem and resolve it in a way that does not rely on the law, but also a way that is not very acrimonious. So I then got trained in mediation process. And there's a 40-hour mediation process that you have to do to become a mediator. I trained in that, and I did another 40 hours training to train trainers, so to train other mediators. And I felt very equipped. But one of the things that was very interesting about this mediation training is the fact that when you are mediating, they tell you that there's this opening statement that you have to say when you are opening a mediation. And this sets the scene for how the mediation is going to take place. So you come into the room and you tell the parties that this is a voluntary process. So at any point, you may leave the process if you're not happy. That it's a confidential process. So everything that we're going to say here is going to be kept confidential. And that at some point I may separate you as parties. And even when I separate you, what I discuss with one party is going to be kept confidential from the other party. You also explain the fact that you are neutral, so you don't really have an interest in the outcome of the process, and you're impartial. And also that you are going to allow the parties to make their own decisions. This is a process where they are going to self-determine the outcome. You're not going to give them opinions, you're not going to give them guidance, and you're not going to be the judge. You're just going to be helping them to determine and facilitate the engagement. So you get into the mediation process and you start this wonderful process. And I've been mediating now for 13 years. I've done mediations in South Africa, Rwanda, Uganda, Kenya, Liberia, Ethiopia, in so many countries. And there were consistent questions that kept coming up from parties in the process, which began, to puzzle me a little bit. One is, when you separate the parties and you go into this private caucus, the minute you come back, the one party wants to know, what did the other party say whilst you were gone? Now, the process of mediation and what they also teach you is that you're trying to build confidence. People must trust you, and you're trying to kind of create a relationship with them so that they can trust you and they can open up. The more they open up, they will really share what is going on so you can help them resolve the issue. But then the other party becomes quite suspicious when you're not able to tell them what it is that you were discussing with the one party. So let's say you were in the room with another party for 40 minutes, you come back and you say, okay, so let's pick up where we left off. And it's like, well, what did they say? What have you been talking about? And you're not able to assist in that situation. The other thing that they always ask is, okay, we are at this point, what would you advise for us to do? Can you give us any advice from the experiences that you've had with other parties? What would you say is the best thing that we should do? And your response as a mediator is like, well, you know, I explained this to you in the beginning. I'm just here to help you talk. I'm not really here to make any judgment. I'm not here to give you advice. And I became curious, why are people asking these questions? Because if this is how mediation is supposed to proceed, there's supposed to be a natural understanding. And I went to do some investigation on different traditional mechanisms that had been used in Africa. And like I gave you examples of countries that I mediated, most of my mediation has been focused on the African continent. So I looked at the ways in which traditional justice was done in Africa. And you find, for instance, that the issue of it is voluntary. It's not really voluntary. You come to the process because there is a dispute. You have no option that I'm just going to walk out and I'm done, you know, because if it's not resolved in one place at the particular time, it has to continue, you know. And in other instances in African tradition, the mediator and the arbitrator is doing the exact same role. The first part of it, they try and coerce the parties and just encourage them to come to their own decision. And if they are not going to come to a decision, then the mediator goes into a decision and makes a decision on behalf of the parties. So it's not necessarily voluntary. The issue of confidentiality is completely in contrast, because these processes are usually held in a public place, whether it is under a tree or in a market or in a palace or whatever, and people who are interested in the conflict come to hear what is going on. They not only come to hear what's going on with the conflict, they are also able to give their own stories as people who are not involved in the dispute. So it's not just a public thing, it's just open to people who feel that they have a vested interest as community members to contribute to this topic. So confidentiality and transparency seemed to come head to head, you know. And the issue of self-determination as well was also a little bit problematic. And then you begin to understand why people are always asking you, so what do you suggest? Because in their traditional experiences, they talk, and when they get to a place where they can't make decisions, somebody makes a suggestion or somebody makes a decision. And so that became a bit of a conflict for myself, who's a practitioner. I am African, and I was Western trained, and most of the conflicts that I'm resolving are in traditional rural settings, whether it's Africa or some of them are in Southeast Asia. And some people were saying, you know what, it doesn't really matter that, you know, you're coming to use a different model. The point is, if you're able to help parties resolve the conflict, that is the thing that is relevant here, you know. And you begin to look at why may it be important for parties to actually use a system that is familiar to them. So I found a study that was done in Australia with the Aboriginal community, where they had, after many years of having introduced ADR into the court system. Now, they introduced ADR in the court systems mainly because they say that, you know, there are costs that are high, that processes take a very long time, and lots of people who are, you know, not economically able to afford the cost of the lawyers and the length of the time that it takes. But also, some studies show that the use of foreign language in the courts, the use of foreign processes that people are not familiar with, alienates them. That they don't even go to court to begin with. A study was done in Liberia that showed that about 1% of Liberians refer matters to court. If they don't refer to court, they take them to the traditional justice system. If they don't go there, they don't go anywhere. They kind of just let them go and deal with them in other ways. Well, there's also violence. But if you see that in some instances people feel alienated with these traditional systems, 10 minutes. Oh, that's a lot.
7 minutes.
Oh.
We have more time.
Okay. So if people are being alienated by these systems, and in Australia then they introduce ADR because they feel that it's an informal way of resolving conflict, and people may be more open to it. And the Aboriginal people say, actually, no, we don't feel that way at all. We feel that ADR alienates us. And they were saying, well, why does it alienate you? And they were saying, well, first of all, it is a concept that we don't use. So it is an introduction of a Western dominant culture, again, into the justice system, which we are not familiar with. But secondly, it has the ability of taking the conflict and privatizing it. It takes it away from the community where the conflict is taking place. You bring in a neutral person who is not part of the community, who is not conscious about issues of social cohesion, the way in which elders, when they're doing these processes, would be, where they would be going. You may come in and you may be interested in helping the parties resolve the conflict, but you're not really interested in the general keeping of the social cohesion of the community. And so this is not a process that we find that, you know, is working for us. And then elders become redundant. There is no role for the elders anymore in dispute resolution. And I thought, you know, because the culture and the traditional justice systems of the Aboriginal people is so similar to the African people, this possibly may be also an unintended outcome of introducing ADR into our communities. But the second thing is that, you know, when you look at the reasons and the history of how we came to have these justice systems that we have, we had colonial people, colonial masters who came from France, Portugal, Spain, or wherever they came from, and they came into Africa, and they had justice systems that they put in place. They didn't put them in place thinking that, well, let's live happily as a community. No, that there were racist principles that governed those systems that we had. There were gender principles that governed them. And what they did was that they looked at the traditional justice system that was existing, and they felt it's a primitive system. They devalued those systems, and they elevated the justice systems as we know them now. You fast forward many years after colonialism, those systems are still there. We use the exact same systems, and there's even been a push that, you know, in some of the countries, the laws are exactly the way they were when the colonial people left. So the people need to update those laws, you know. So you find that those are the justice systems that were put in place. People say that they don't use them because they were foreign systems, they can't relate to them, they have all these other kind of undertones of racism and gender and whatever. And then in trying to assist to address those issues, you introduce an ADR process into the courts. And the same ADR process that you're introducing, those principles developed in Australia, in the US, in the UK, you're bringing them back into the continent, you know? And it does become a little bit problematic. Now, what does that mean for me as a practitioner? What I didn't explain in my opening is what I actually do. I'm part of the World Bank Group. And what we do at the World Bank Group, we're a unit that gets activated when a bank project goes wrong. So the bank will give funding to a private sector client. They will either be constructing a road or a hydropower or a mine or something. They will be doing a project in a country, and the community that lives within the vicinity of that project will then come to our office if they feel that there is something that is going wrong which impacts them. It will be maybe an environmental or a social concern. Either they are polluting the water, or they have displaced us from our home, or they have killed our livelihoods. So they will activate our office, and we do one of two things. We can investigate the role of the bank to see what did the bank do, and what is the role of the bank in having created that situation. Or we try and get the parties to sit down and resolve the conflict. So the parties would be the community and the bank client. We possibly have to bring in the government, particularly if issues of land are involved. So now, having come to this conference and hearing all the issues that have been brought up around traditional justice, what Pat has spoken about, the different kings from Nigeria have alluded to some of them, and a lot of the other presentations from the other countries, which are pressing on us as practitioners to be looking at how do we incorporate traditional justice systems, because it's an important thing. And then I go to a country like Myanmar, where the community comes and they say, we have a problem with the project. And the person who is the project or the client of the bank, they come from Singapore and Japan. It's a joint venture from Singapore and Japan, and they are operating in Myanmar. And the people from Myanmar have called us, and we are coming in from Washington, D.C. I'm an African, but I'm based here, and I'm trained in the Western model. And then you sit there and you think, well, this is an interesting thing. Let's just suppose we were going to do a traditional justice process. Which one do we take? Whose traditional systems? Do we look at Singapore? Do we look at Japan? Do we look at Myanmar? Do we look at mine as African? Do we look at whose are we using? And I feel it is very good and very nice for us to do this research and push for this movement going forward. But we work in a very multicultural environment. And what do we do as practitioners, you know? Because we can hear you as academics and researchers who are pushing for this, but what is my solution in my environment that I'm working in? And so I will leave it to you.